Good evening. MA Philosophy MAPY Block number 3 Unit number 11 Alternative Dispute Resolutions. Introduction. There are two broad categories of approaches to solve disputes, violent and peaceful. Often violence carries a connotation of reproach or disapproval from an ethical or religious authority. Buddhism and Jainism are two examples which prohibit adoption of violence as a means of resolving any issue. Also, violence is becoming increasingly non-feasible, non-practical, counterproductive, and indeed self-destructive in the nuclear age. As civilian spreads and rational approach expands, violence gives way to debate and discussion, bargaining and sharing, peaceful coexistence and peaceful competition. In the present world, more and more peaceful methods are being explored and employed to resolve conflicts through peaceful rather than warlike or violent methods, internationally and domestically. Aims and objectives. This unit would enable you to understand the concept and meaning of alternative dispute resolution (ADR) areas in the domestic sphere and abroad, areas in India. Violent option. Since conflicts are universal, efforts made to solve them over the centuries across the world have been plenty and very plenty and variegated depending upon the gravity, nature, extent, and urgency. Conflicts have been resolved or attempts made to resolve successfully or otherwise. Until recently, that is the turn of the 20th century, violence or war was accepted as a normal, legal, and final way of settlement of disputes among the community of nations. Within the domestic sphere, violence has a limited but nonetheless significant application. The state had a right almost monopolistic of violence against its own citizens who had transgressed the laws of the land etc. Also civil violence, that is violence unleashed by one set of civilians against others without the permission of the state was a common phenomenon everywhere. Though laws and politics were supposed to tackle it, civil violence could not be anticipated, eliminated, or even managed successfully by the state or other civilian organizations. Movements, political and social strikes, protest and frustration over state inaction, ethnic and territorial claims, attacks by criminal terrorist element and sabotage were all but few of the cause of occurrence of violence in the domestic sphere. Non-violent efforts to contain, manage, reduce and eliminate violence in society have to be differentiated. At the international level, it may be simpler to evolve a mechanism to tackle violence as there are nearly always only two parties, the states add to the dispute. At the national state level, the answer to violence has to be found in a much more complex manner. In the following pages, some details are discussed in a comprehensive manner about the various means adopted to tackle conflicts, first at the international level and later at the national one. Negotiation. Through the long uses of customs, practices, and conventions, one learns that violence or resort to violence in interstate affairs was not the first option, either on their own or at the behest of others. States in conflicts tried their hand at peaceful methods of settlement of dispute. Time honored and practicable way out of any conflict is to talk to the opponent. Of course, it is a difficult and complex process of opening the talks. Who should talk to whom, at what level of authority, what should be aimed at, what portion of the structured problem should be addressed? Should the talk be open, confidential, or back channeled, totally non-formal? Should the solution be claimed as a compromise, victory for one side, or merely a tactical arrangement for the time being? And how far are the steps or process of implementing solution binding on the parties, etc., are the questions which needed to be asked and settled if the talks are to be of any meaning. In the process of talks, the substance of the dispute has to be identified clearly by both the parties first, and then attempts have to be made to sort out the differences between them. This is popularly known as negotiation. Reasoning or logical argument may pave way for an amicable settlement of the dispute. Mutual trust has to be established, and then a mutual give and take has to be arranged. Finally, an open or partially open statement of settlement has to be announced. Often, a series of round of talks, held sometimes away from the public glare, has to be held. It is also true that many a time strenuous, quite diplomatic round of talks are held, which lead to durable solutions. If the substance of the conflict dispute is complex, technical, or multidimensional, like GATT, WTO, WTO, nuclear weapon control, climate control, etc., it is necessary to involve technical experts in the negotiations. In the earlier centuries, the subject of interstate dispute used to be more often than not political. Nowadays, the disputes are complex in nature, be it economic, technical, or military. Not only would there be a multi-layered but also multilateral and multidimensional understanding of dispute, the official ambassador or diplomats apart, there might be appointed special negotiators and technical experts attached to the negotiating term. Nowadays, the holding of conferences for multilateral negotiations involving a large number of delegates is stretched over a number of years with an enemy of hospitality and secretarial assistance has become a lucrative business indeed. In Geneva and New York especially, the United Nations hosts or calls for several such conferences every year. It is also noticed that in these days of complex negotiations, the main burden of holding talks falls on the professional diplomats and technical experts. Yet there is a great need to get back to the authorities at the headquarters to authorize changes in the basic position of negotiations. The mass media and the academia also exert enormous pressure on the negotiating posture. Not only political and technical but also psychological aspect of a negotiation need to be studied carefully. If back home there be democracy with an active opposition and mass media, the task of selling a negotiated settlement, although reasonable, would turn out to be difficult. When negotiations are stuck with an impasse or deadlock, it has now become fashionable to hold a summit meeting that is the heads of governments concerned would meet to take stock of the situation and give modified instructions so that progress in negotiations is made. Summit conferences have to be late become popular. They have given good results, no doubt, but at times they tend to make things difficult when prior preparations are not made properly. Often the personality clashes do occur and cause a setback to the process of negotiations. Kennedy Khrushchev meeting in Vienna and Nehru Ayyub or Nehru Chow and Lai meeting could be cited as examples of summit backfire. The 1972 Simla meeting between Zulfikar Bhutto and Indira Gandhi too has been cited as an example of unwarranted summit diplomacy which could have been better avoided, and the normal diplomatic negotiations could have achieved better results. Those negotiated settlements are better which are backed on both sides by a clear understanding of a basic issue, and number B, the barter of give and take, hasty, ambiguous, pre, presur, presurize pressurized and highly personalized solutions are no substitute for properly reached, widely consulted, and fair settlements. It is important that a conducive atmosphere should be built when negotiations are held. Usually, negotiated settlements end in the announcements of a joint agreed communique, or if the matter is significant, is a treaty agreement. The United Nations expect that all treaties agreements reached between states are filed with the Secretary General's office. All agreements reached after negotiations are expected to be implemented in good faith by all the parties concerned. This is one of the principles in the international law. In the new age inaugurated by nuclear weapons, the significance of negotiations has increased considerably. In the earlier times, wars were feasible and called frequently, but having made war almost obsolete, the weapons have pushed negotiations, including those with a tinge of deterrence, to the fore. For no state today is in a position to say, "I declare war unless my terms are met." No state can achieve its objective through a nuclear war, as it would perhaps have got in the pre-nuclear age. War was a continuation of a policy by other, that is violent means, as von Clausewitz states so succinctly. But now negotiations are almost the only means of solving interstate disputes. The space vacated by war is occupied by more negotiations. After a series of brushes with adventurism, both the nuclear superpowers US and USSR learned to live peacefully without further testing the nerves of the statesmen on the launching of nuclear warfare. 1962. Before ending this portion on negotiations as a normal and favorite technique of conflict resolution, it may be worthwhile to remember why negotiations failed many a time. To quote the summary of a study made in this regard by one William Jerthman, The Sage Handbook on Conflict Resolution 2009, probably the most challenging issue of the time concerns the profound change in negotiation brought on by a changing nature of parties negotiating with armed bands, terrorist, anti-globalist movement, among others, are not are not the neat two-party negotiations the current analysis so often assumes. Not only does it involve internal politics, as do all negotiations, but the other party frequently does not exist as a corporate body. There is no leader who can make a decision and hold an agreement, and no delegates who represent the central organization. Furthermore, the party frequently does not know what it wants. Finally, these parties usually do not know how to negotiate and often have to be taken aside and given training, as in the as in Darfur, Mozambique, and Sri Lanka in recent conflicts. Negotiating with or between uh, amorphous parties needs entirely different models to capture its process in concept and in reality. Mediation. If the parties to a dispute conflict talks with each other, it is described as negotiation. Sometimes it is not possible for a variety of reasons for states to take up talks with with the opposite party directly. They may be willing or half willing, and yet they are not in a position to open negotiations. Under such circumstances, it is fortuitous if a friendly state entity, institution, or even a person of standing were to come forward and bring the parties to the dispute to a negotiating table. Use of good office, you offer of an honest broker, and hosting a Hosting a goodwill conference may be some of the forms of bringing friends together so that they may overcome their initial reluctance and begin to talk. The part which facilitates this process is called mediation. Through this method of mediation, negotiations are given a fillip and a solution is facilitated without resort to war. Mediation definition and characteristics. In a brilliant study of mediation as an instrument of conflict resolution by Jacob Jacob Verkovich, The Sage Handbook of Conflict Resolution 2009, the following points emerge. The task of the mediator is not an easy one. The sea that he sails is only roughly charted. He is a solitary artist, recognizing at most the few guiding stars, and depending on his personal powers of divination, as Arthur Mayer would put it, or an Young, a renowned scholar in the field, would define mediation as any action taken by an actor that is not a direct party to crisis, that is designed to reduce or remove one or more of the problems of the bargaining relationship, and therefore to facilitate the termination of the crisis itself. In simpler terms, it is suggested that mediation is a form of third party assistance which involves an outsider to the dispute who, however, lacks power to make decisions for their parties. Linda Singer, it may be a bit naive to believe that a mediator is altruistic. Maybe so at times, like our own Pandit Jawaharlal Nehru vis-a-vis Korea. Usually, the mediators have got their own hidden agenda, which may not be significant yet not negotiable. The relationship between a mediator and disputants is hardly devoid of political interest. Considering a number of incidents of mediation in resolving interstate conflicts, it may be safe to assume that the following constitute the essential characteristics as brought out by Jacob Barkovich. Mediation is an extension and continuation of peaceful conflict management. Mediation involves the intervention of an outsider, an individual, a group, or an organization with values, resources, or interests of their own into a conflict between two or more states or other actors. Mediation is a non-coercive, non-violent, and ultimately non-binding form of intervention. Mediators enter conflict, whether internal or international, in order to affect it, change it, resolve it, modify it, or influence it in some way. Mediation is a voluntary form of conflict management. There are quite a number of examples of mediation in international conflicts in recent years. In the Sri Lanka Leyte conflict, the Netherlands have assumed this role, and then U.S. President Bill Clinton played a notable role of mediator facilitator in arranging direct talks between Palestine and Arab parties, and got Camp David Accord signed by them. Pandit Jawaharlal Nehru Krishna Mohan played a significant role in bringing of a truce between Korea, China, and the US in 1953, and in the ongoing conflict over Kashmir, several unsuccessful meditations have been sponsored by the UN. More often than not, mediations receive a mild and skeptical reception. The outsiders hardly understood the complexity of the issue issue one hand, nor do they have a great stake in the resolution of the conflict. Nowadays, the US, being the only superpower, global power, envisaged a role for itself in resolving any conflict anywhere in the world. The American diplomats are generally well served by area experts or subject experts. They are also a determined lot. If the US president wills it, it would be pursued relentlessly. Sufficient sufficient incentives or penalties are dangled before the eyes of the disputant parties so that the American suggestions are taken up and implemented. However, it is noticed that the US policymakers turn their faces away from the issues or if their own public opinion is not expressly in favor of rule for the US. The well-known ethnic atrocity and breakdown of political stability in the former Yugoslavia did not figure anywhere in the first presidential election campaign of Bill Clinton. In the second campaign, it was a big issue. When the US public is obsessed with its own enemy and politics, it adopts a divine silence over the foreign issues. If, on the other hand, it wishes to bring order to the world, the US leaders jump into the arena of conflict and whistle with it whether or not its role is useful to the disputants. Often they leave the field without settling the issue. Hence, mediation, especially by in the US, is full of uncertainty. In Afghanistan, Pakistan, Iraq, and Iran, the US mediation through the UN good offices met with met with varying degrees of success failure. Mediation as an instrument of conflict resolution in international sphere has got limited application. Adjudication. The United Nations was set up in order to ward off wars and instill in the hearts of men hopes of peaceful settlement of dispute. In its charter, Article 33, the UN envisages almost all the peaceful ways of resolving international conflicts. Parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their choice. The preferred approach of the UN is clear, either a political negotiation or a judicial settlement. Lending scholars in the field of jurisprudence and visionaries, peace through justice led great emphasis from the time of the League of Nations upon a judicial settlement of international disputes. Following the Treaty of Versailles 1919, the first ever international forum for adjudication of interstate disputes, the Permanent Court of International Justice (PCIJ) came up in 1922 at the Hague. According to their belief, if the world has to get rid of wars which were threatening the very civilization on this earth, there was only one hope and one solution, which lay in the hands of one impartial and wise judges of international repute. The PCIG, however, proved a dampener, not so much because of its own limitations, but because the states were not as yet prepared to hand over to it their political power to decide any issue. The PCIJ existed for 18 years. It ceased its functioning once the war broke out, and the ceased to exist after the League of Nations, of which it was a part, was formally dissolved in 1946. In its brief existence, the court handled 29 cases of litigations as well as 25 advisory opinions. It was regrettable that powerful states did not show anything more than lip sympathy to the court. When the United Nations was set up in 1945, the International Court of Justice (ICJ) was also brought into existence. Along with the Charter of the UN, the statute, statute on the ICJ was also Statutes. Statutes. The PCIJ, however, proved a dampener, not so much because of its own limitations, but because the states were not as at prepared to hand over it to their political power to decide any issue. The PCIJ existed for 18 years. It ceased its functioning once the war broke out and ceased to exist after the League of Nations, on of which it was a part, was formally dissolved in 1946. In its brief existence, the court handled 29 cases of litigations as well as 25 advisory opinions. It was regrettable that powerful states did not show anything more than lip sympathy to the court. When the United Nations was set up in 1945, the International Court of Justice (ICJ) was also brought into existence. Along with the Charter of the UN, the Statute on the ICJ was also presented for signing. The court was made a wing of the UN Article 7. However, the jurisdiction jurisdiction of the ICJ was not enforced upon the member states of the UN automatically. Each state which became a member of the UN has to register separately its accession to the jurisdiction of the ICJ. However, many states have refused to submit themselves to the jurisdiction of the ICJ compulsory jurisdiction. What is worse and important, a state like the US has withdrawn its earlier consent. A large number of states have accepted the jurisdiction with certain exceptions or conditions which, in effect, take away the effectiveness of the court. As a result, the ICJ has not been an active body worthy to cite for its contribution to peaceful settlement of international disputes. During 1946 to 2007, the ICJ, it is estimated, has passed 92 judgments on disputes raised before it and given 25 advisory opinions. Many of the cases referred to it were to minor significance or of no significance. Though the court's performance has not been brilliant, it has nonetheless influenced the evolution, development, and codification of international laws, especially those dealing with the laws of seas, environment, treaty interpretation, economic questions, and issues related to asylum. The effectiveness of the ICJ has been affected adversely by the so called big powers like the US and France who have treated it with contempt. Na- Nic- Nicaragua complained to the ICJ in 1984 in that the US was interfering in its domestic political establishment. The CIA of the US was accused of armed help, training, and financing of the Contras who were opposing the rule of domestically elected Sandinista government. Instead of proving its innocence or admitting guilt, the US withdrew itself from the jurisdiction of the ICJ and justified its stand by referring to domestic compulsion. The ICJ nonetheless proceeded with the complaint of Nicaragua and pronounced its ruling in May 1984, which indicted the US in no uncertain terms, but its impact was negotiable on the outcome of the conflict. It is noteworthy in this context that India has accepted the findings of the ICJ in two cases it was involved, one over Goa vis-a-vis Portugal and another over the run of Kutch vis-a-vis Pakistan. On the whole of reputation of the judicial mechanism to solve international conflict is not enhanced by the functioning of the ICJ. It does not have enough work to do of late, yet the glimmer of hope survives. Recently, in 1998, the Rome Conference, sponsored by the UN, adopted the Statute of International Criminal Court, which came into force on July 1, 2002. Once again, the US threw cold water over its functioning by opting out of its jurisdiction. There are several international tribunals which have been specialized and and have been functioning with greater utility. Some of these are ad hoc international criminal tribunals which dealt with the uh, occurrences in Yugoslavia, ICTY, and Rwanda, ICTR, International Tribunal for the Law of the Sea, European Court of Justice, European Court of Human Rights, Permanent Court of Arbitration, etc. The overall situation remained a bit disappointing, though the scholars and visionaries lay a great stone by the judicial institutions, chiefly the ICJ, for solving in a rational manner the vexed problems of international affairs. The performance of the court as well as the behavior of the big powers have proved to be a big letdown. One incident of the court proving itself to be of weak and vacillating mind showed up in 1966 in a case related to the use of nuclear weapons. It follows from the above mentioned requirements that the threat or use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflicts and in particular the principles and rules of international humanitarian law. However, in view of the current state of international law and of the elements of fact at its disposal, the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstances of self-defense in which the very survival of a state would be at stake. Many scholars have ridiculed at such a weak need judicial approach to solving conflicts peacefully at the international level. The adage that law rule over the poor while the rich rule over the laws comes close to the description of the working of the judicial forums in the community of nations. There is another adage which also comes to mind: the laws are silent when the guns boom. ADR in domestic sphere and abroad. Alternative dispute resolution. ADR has been recently in phraseology but old in concept. In the days gone by, laws were not made by any parliament or even by kings, but were laid down in the scriptures and treatises. Resolution of conflicts disputes took place also in the manner laid down in these books, customs and practices. Naturally, There were changes in these methods in keeping with the changing times, but with the coming of modern times of democracy and constitutional governance, the method of judicial pronouncement has become the primary one in the resolution of conflicts in the domestic sphere. Of late, that is, in the past few decades, the load of work of the judiciary has increased enormously, causing undue delay in dispensation of justice. Also, too many rungs of judiciary can be cause of delay. The poor and distantly located people find it hard to pursue their cases in law courts through a better of costly lawyers. Alternative forums, which could prove to be cheap and easily accessible, have of late been tried. These are called alternative dispute resolution mechanism (ADR) abroad. In Europe, where there existed strong judicial institutions, people were generally disappointed with the slow grinding of wheels of justice. It also proved to be costly and made to suit the skills of lawyers rather than the need of the parties. In the UK, the ADR took birth in 1974 in the form of Advisory, Conciliation and Arbitration Service. In 1995, France expanded the legislative basis for judicial conciliation and mediation. Earlier in the US, following the remarkable dissertation produced by Roscoe Pound entitled Public Dissatisfaction with the American Legal System, a wave of judicial reforms took place. The new ADR limitations came in, and within a few years, nearly 93% of civil disputes were disposed of without going for trial in the normal judicial forums. In Japan, the judges intervened extensively during the in-court proceedings. They removed their formal judicial robes and participate in settlements talks as a friendly mediator. This gesture is appreciated both by the litigants and lawyers. In China, the dictates of Confucius on the importance of harmony in family and society have come back to influence the disputants and helped in reducing litigations considerably. In Hong Kong, the International Arbitration Center, the biggest in Asia, have gained immense popularity and prestige because it is a fair and helpful to the clients. ADR in India. Before the onset of the British rule, India has had a sound and time-tested judicial system. People might have been hierarchy conscious, caste-ridden, and illiterate, even winded by outward religious beliefs, but all had their own ways of settling dispute. When the British took over administration, ado- they found it abominable to go by the traditional Indian practices of resolving disputes. They introduced, rather imposed, a new legal regime here. This gained some popularity among the educated elite. In due course, the new system emerged strong and attained uniformity all over India. However, the workload of the courts and the cost of uh, litigation, as well as the long delay in procuring justice, even in simple cases, compelled the government to introduce ADRs so as to ease the burden on the judges and litigant public. The lawyers, though initially unhappy, have come round to appreciate the functioning of ADR. Some time ago, 2006, it was estimated that there were pending 2 crore 53 lakh 80,757 cases in the subordinate courts in India. To try these cases were to try these cases were available if all the posts were filled up. Less than 50,000 judicial officers, judges. This ratio being judges to population works out to be 105 judges per 1 crore population in India, whereas it is 509 in the UK, 577 in the Australia, 752 in Canada, and 1070 in the US. This figure does not give a total picture. The litigation cases filed by the people are not taken into account. After the ADR was introduced, several thousands of litigations have been disposed of without causing any adverse reactions from any quarter. This experiment was initiated with the passing of the Legal Service Authorities Act 1987, which has been amended from time to time. In 2002, Section 89 of the Civil Procedure Code was modified to incorporate conciliation, mediation, and pre-trial settlement methodologies for prompt and inexpensive resolution of disputes. Lok Adalat. The origin and importance of Lok Adalat are given above. The salient feature of Lok Adalat, People's Court, are mentioned as law. Lok Adalats are legal and authentic forums of justice. Lok Adalats are constituted from time to time in order to solve the number of cases pending before regular courts for disposal. There may be specific Lok Adalats for cases related to water, electricity, banks, pension, transport, etc. Lok Adalats are presided over by the sitting or retired judge along with a social worker and a lawyer. The cases are transferred to Lok Adalats from regular courts on demand. There is no court fee to be paid to Lok Adalat. If any fee is paid to the regular courts and the case is transferred to the Lok Adalat, the fees already paid would be refunded if the dispute is settled. Lawyers' assistance is not necessary, though they may offer help. Legal procedures are not followed strictly. Flexible and liberal attitude adopted. The client's parties to a dispute can interact with the judges freely, which is not possible in a regular court. If the parties to a if the parties to a dispute agree in the Lok Adalat in a compromise, the case is deemed settled with no possibility of appeal to a higher courts. If it is a judgment by consent, following the success of Lok Adalat experiment in the public domain, private and business organizations too have adopted the model and doing a good job of it. Sometimes the nomenclature is changed to ombudsman etc. Essentially, the concept of Lok Adalat or ombudsman is to help people to help themselves. Thus, the tension is eased and finding a mutually agreeable solution is facilitated by this experiment. Its immense popularity is understandable. It is an eminently sensible and feasible mechanism of peaceful resolution of conflict in a civilized society. Summary: there are different ways of conflict resolution. Traditionally, war has been treated as a form of settling dispute, but as civilization spreads and rational approach expands, violence gives ways to debate and discussion, bargain and sharing, peaceful coexistence and peaceful competition. In the present world, more and more peaceful methods are being explored and employed to resolve conflict through peaceful rather than warlike or violent methods, internationally or domestically. Mediation, negotiation, dialogue, arbitration, adjudication, and so on are increasingly being recognized as methods of alternative dispute resolution, areas that have become more acceptable, especially in recent times. In India too, Lok Adalats have been playing a significant role in settling disputes. Thank you.